Oh, hey, folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, pull up your chair and get your pen out and take some notes because we've got a great question from our YouTube subscriber here today. Hey, Patrick, could you please help us understand the right of survivorship law in joint ownership of holding assets? Folks, right of survivorship, joint ownership of an asset, from my experience, could be Bill and Mary, married 50 years. They put their names on the deed to the home. They put their names together on the bank accounts, on the investment account, and whatnot. And that can work to avoid probate, and it's only temporary because Bill checks out, goes up to the cloud. You have the legal right of survivorship law to wife Mary, which is good because that will avoid probate court. Where it's bad and detrimental is Mary, from my experience, all the assets typically will remain in Mary's name individually, folks. And this is a big legal technical takeaway. If an asset is in your name individually without a joint owner, and without a beneficiary, where's it going to go? It's going to go to probate court. Now the kids are hiring probate attorneys unnecessarily and starting the journey through the probate court process, could be for a year and a half or longer, paying by the hour. Unnecessary, folks. So joint ownership, folks, typically doesn't work so well. Other scenario, Bill passes away and she's thinking, a friend told her, hey, Mary, you better put your kid's name on the deed to the home. You better put your kid's name on the investment asset or that stock certificate because that will avoid probate court. That's very highly detrimental because now the kid's going to get hit with capital gains tax, the second-headed monster. Very detrimental because the kid's going to acquire your carryover basis, what you paid for that asset. They're not going to get your stepped-up basis called date of death value under Internal Revenue Code 1014. So do not put people's names on your assets, folks, typically detrimental. And right of survivorship law, folks, is not a good solution to avoid the metaphorical four-headed monster. Certainly not a good solution for long-term avoidance of probate court, as we just illustrated. So what is the difference? Bill and Mary now get that education, get that knowledge by reading my book, attending one of our educational programs, or watching this video. And then they're like, hey, we need to follow Patrick's 3-step treasure chest process because we don't want the kids spending 50 grand in probate. So we're going to create a trust, step 1. But Patrick teaches us after we design and sign our trust, it's not a magic red book. We need to engage in step 2. We need to get all our treasures in our treasure chest. We're going to retitle the home now to our trust, the vacation home to the trust, the non-real estate to the trust. Now, when Bill passes away, Mary is the surviving trustee and beneficiary. She can access the money and have the use and enjoyment of the money in the homes and so forth. But when Bill and Mary designed their trust, they named their number 1 son, their oldest child, Mo, to be the alternate successor trustee. So even when Mary goes up to the cloud now, this is the big win right here. And this is the distinction between joint ownership and a funded trust. Mo now has a key to the treasure chest. Day number 1, when his mom's disabled and or when she passes away. And now the family avoids probate court. Game changer, folks. Because sadly, people die, but trusts do not. So getting your treasures, folks, into your treasure chest is of paramount importance, folks. Step 2 of our 3-step process, because that is where the rubber meets the road. That is where all the magic happens. The magic is avoiding probate court, the expenses, the costs, the delays, the messes and stresses of probate court. So folks, please follow that advice. This is not a do-it-yourself project. Work with your experienced elder law attorney that has a formal trust funding process like we have here at our Elder Law Care Center. And you want to be an equipped, informed consumer, and please ask your elder law attorney, do they have a formal trust funding process where they will assist you transfer and fund all your treasures into your treasure chest properly? Not just the house, but the non-real estate assets as well, because you want to avoid probate court at the end of the day. And from my experience, survivorship is a weak strategy to do that. Not sufficient enough. All right, folks, go get it. Click the subscribe button. Click that notification bell because we will continue to keep you updated. Pick up my book on Amazon, The Top 20 Elder Law Questions. It's a rather robust book. Questions and answers, 21 chapters. I have 20 chapters and 1 bonus chapter. I hope you enjoy it. I know you will. Thanks for being here today.